Do not send me to jail. I would not put you here. I know you still got some type of love for me. You're not going to press charges, but I know you really don't want to see me rise to jail. You're going to send me to jail for 10 years. Me writing you in your spit on your face. That was just childish. I apologize. Yeah, Your Honor.
Senator Dumpy Lebo on behalf of Mr. Larry.
Hey,
Mr. Larry.
thank you. You're looking for an adjournment.
I am, Your Honor. We're requesting some media.
You may.
Your Honor, give me my attention. While the defendant was in custody, he made 3 calls to the victim from his PIN to her listed number. In those calls, he says things like, I'm in jail for 3 days. I've been here every day. What his bond is set at. He also states things like, we really can cut all that shit out. We can go our separate ways. Do not send me to jail. I would not put you here. I know you still got some type of love for me. You're not going to press charges, but I know you really don't want to see me rise to jail. Might not want to talk with you, but I don't believe that. Right, so you're about to keep me in jail for real. You're going to send me to jail for 10 years. Me writing you in your spit on your face. That was just childish. I apologize. Talking about the case, talking about you're keeping me in jail. Are you really going to press charges on me? And so at this point, I'm going to ask him if you're mad and he violated his bond. He's called for after he was arraigned and told not to have contact with her. And he did have contact with her. Talking about the case, talking about keeping him in jail and like that. So I have concerns. And ask him to hear me that started to violate his bond.
Response, Mr. Allen.
Your Honor, Mr. Larry's indicated to me that these calls would have been made prior to the arraignment. I understand.
It would have been made prior to his arraignment?
That is what Mr. Larry's indicated to me. I haven't been able to verify that myself.
What's the date of the calls?
And the calls are from 26th. Along with one on 325 that was later in the evening. After he would have been arraigned.
I did discuss it with Mr. Larry. He does understand that.
Still want to keep representing to the court that they were made prior to his arraignment?
Yeah.
What?
Oh, Your Honor.
Yeah, because that wasn't true. All right, go ahead, counsel.
Your Honor, all I can say is that Mr. Larry did indicate to me that he believed they were prior to his arraignment. I'm glad that he's...
Seriously? No, he didn't.
I'm glad.
Just saying that.
Yes, I'm glad.
He just got you to just say it.
Yes, and I'm glad that he's now come clean about that. He certainly understands that he cannot have contact.
She has to check any text. Wait a minute.
It's not helping.
Anything else?
I have nothing to add, Your Honor.
People's motion to modify bond. It's granted. Defendant's bond is hereby ordered revoked. Defendant's remanded back to the Washington County Jail. Court, they will also order that his phone privileges and texting privileges are hereby revoked. Defendant's remanded.
Thank you, Your Honor.
This first hearing turns on something far more damaging than the underlying accusation, alleged contact after the court had already ordered the defendant to stay away. The prosecution points to calls from his jail PIN discussing the case, asking whether the alleged victim will press charges, apologizing for biting her face, and pleading not to be kept in jail. Those statements matter because a no-contact order is designed to prevent exactly this kind of communication while a case is pending. But notice the credibility problem that develops in real time. Defense counsel initially relays the defendant's position that the calls happened before arraignment. Once the dates are identified, that explanation collapses, and even the defendant apparently acknowledges it was not true. That leaves counsel with almost nothing factual to defend. Judge Simpson's response, granting the prosecution's bond motion and cutting off phone and texting privileges, is therefore aimed at enforcing compliance and preventing further prohibited contact. Would you trust another promise to follow the rules after watching the timeline unravel this quickly?
Calls the case, People versus Wardell Smith.
Morning, I'm Wardell Smith, who's approaching the podium. Wardell, would you state your name for the record? Wardell Smith Jr. Judge, this is a PCC matter. I've had a chance to speak with Mr. After discovery. We're asking you to sit for an exam.
All right, preliminary examination will be set for, will people have their witnesses available the 14th? Set preliminary examination, April 14th, 2026, 9 a.m. That is before Judge Moore.
Judge, may I address bond?
Well, both of you want to address bond.
I think I should go first.
Why is that?
because I know what she's going to say. So I want to beat her to the punch.
Okay. Go ahead.
Judge, no, not to be facetious, but my understanding he's got a $50,000 10% bond. This is incident between he and his wife, a long-term marriage. My client is asking that if the court would consider a $5,000 10% bond tether if necessary. He's the sole support of the family. He will stay away from the marital home as for now, and wants to help work with his children. His daughter's graduating this soon. He wants to be able to be there. So what we're asking for is a reduction in bond.
Response, I guess.
My attention that Mr. Smith has made as a meeting by the last check was 65 calls to the victims listed on which we have had contact before from his PIN since being arraigned in the jail. I and for phone privileges and text privileges to your votes. In those calls, there are terms of giving I love you, baby, things like that. So it's a pretty good idea that it's Mr. Smith and would have to your vote this time for bond remain set, given that he has violated that bond.
Judge, if I may, I thought when I got the appointment, I was told he was out of custody. I did call the one number. It ended up being his wife. She then texted me saying that she would like him home. I told her I can't speak with her anymore about that. That's something for her to discuss with the prosecutor. But again, Your Honor, we're asking if you would please consider a reduction bond on tether.
I'm going to deny the request. He's violating the conditions of his bond, or at least an indication that he has. So I'll deny the request for any reduction in bond. Bond will continue. Defendant's phone privileges and texting privileges are hereby ordered revoked pending a hearing.
The Smith hearing shows why a sympathetic bond argument can collapse when the defendant's conduct appears inconsistent with the conditions already imposed. Defense counsel offers several conventional reasons for reduction: a long-term marriage, family responsibilities, financial support, willingness to stay away from the marital home, and even GPS tethering. Those points are designed to show stability and propose alternatives to detention, but the prosecution answers with the fact Judge Simpson cannot easily overlook: approximately 65 calls to the listed victim's number from Smith's jail PIN, despite the no-contact condition. Even affectionate messages such as "I love you" do not solve that problem. A no-contact order generally concerns whether prohibited communication occurred, not whether the communication sounded threatening or loving. The wife reportedly wanting him home may help explain the family situation, but it does not authorize Smith to disregard the court's restriction. Did you notice how quickly the bond argument changes once those calls enter the record? Instead of deciding whether tethering could manage future risk, Judge Simpson is confronting evidence, suggesting Smith may already be ignoring judicial instructions.
However, on behalf of Mr. Thomas.
Your name?
Everyone Thomas. Thank you, Judge. Today's a date and time set for a probable cause conference. We are asking that we are trying to get Mr. Thomas into recovery court. He was denied from 14A and then 15th District on basically technicalities as far as admission. We're trying to get him in a 14B, so we are asking for an adjournment at this time.
Why is he testing positive for THC?
He has a medical card, Judge, which he has brought with him today.
Did he give that to them?
He did at the time of his test, but they declined to accept it. They said they didn't need it or didn't need to see it. He does have it with him present today.
All right. Wonderful.
Thank you, Judge.
What are you looking to do?
We're looking to adjourn it out to allow us time to get him screened for the 14B recovery court.
23rd, 2026, 9 a.m. Bond.
Thank you, Judge.
Enough people on both cases.
Good afternoon, or good morning, Your Honor. Marcia Cracher on behalf of Ms. Sanders.
What?
Good morning, Your Honor.
Oh.
I'm excited.
Out there, you explored the world, thought the place was better than Washington County, and you're back.
Yeah, it was a long journey, Your Honor. But I'm glad to be back. I'm so happy to be back.
It's like Groundhog Day. It's just going to repeat itself.
Hi.
Well, it's good to have you back.
Thank you.
Your name, ma'am?
Chardonnay Sanders.
Thank you. You need an adjournment.
Yes, please, Your Honor, to ensure I have all discovery and then to share that discovery with my client. Additionally, my client is.
The 9th work for you?
I'm sorry?
The 9th work for you?
Yes, it will, Your Honor.
Probable cause conference will be adjourned April 9th, 2026, 9 a.m. Bond.
Well, my client's asking me to make a bond modification argument, Your Honor.
Okay, go for it.
Okay, thank you. My client's currently charged with 2 cases that are very serious. She understands that, but those are allegations. She'd like me to relay to the court that she's lived in this county her entire life. She has some children that she needs to ensure that are being taken care of. During this time, she has been working on her case service plan for her neglect and abuse case, and she's doing well. She does not have a job at this time, so the bond amount that in each case is a financial hardship for her. She's willing to do a GPS tether. She understands that she needs to come back to court, and she has family in the area that she could stay with and support. So we're asking to lower the amount to a PR if possible and or a 10% component, Your Honor. Thank you.
Front from the people.
And I would ask Bonnie saying she felt over here on the child abuse case and this court. Second charge, she got picked up and she was here before you was assault, very probably harm, less murder. She dad allegedly stabbed her mother's girlfriend in the arm, causing a lot of damage.
My client tells me that she had her cell phone stolen from her, and that's why she missed her court date, Your Honor.
Okay. Thanks for letting us know. Given all those circumstances, I'm not going to reduce her bond. Her examination is coming up, and we can certainly address it at that point in time after the testimony is heard. Motion for bond reduction is denied.
Thank you, Your Honor.
Across these hearings, Judge Simpson repeatedly comes back to the same principle. Asking for more freedom is much harder when the record raises questions about compliance or risk. Larry's position deteriorated when the claimed timing of his calls conflicted with the dates presented in court, resulting in bond modification and loss of communication privileges. Smith sought a substantial reduction by emphasizing family responsibilities and proposing a tether, but the prosecution's allegation of roughly 65 calls to the protected person gave the judge a concrete reason to leave bond unchanged and revoke phone and texting privileges. Thomas presented a different issue. His THC result was explained through a medical card, while counsel sought additional time to pursue recovery court, and the court granted the adjournment. Sanders then requested reduced bond based on local ties, children, financial hardship, family support, and willingness to accept GPS monitoring. But the prosecution emphasized the seriousness of the pending matters and an alleged stabbing causing significant injury. Judge Simpson declined to reduce bond and specifically noted that the issue could be revisited after testimony at the examination. That distinction is important. Bond proceedings are not trials determining guilt. Judges are making pretrial decisions from the information presently before them while considering whether conditions can adequately manage the concerns raised. Which argument here would have carried the most weight with you? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.